Hello, everybody. Welcome back to the AOA live stream. It's so good to have you with us today. And we're going to be covering the recovery time period once again. Last week we hit it with Dennis Block. This week we're hitting it with another powerful eviction and landlord-tenant attorney. So stay tuned here. Before we get started, just want to introduce ourselves. We're the Apartment Owners Association. My name is Jeff and Fowler, and it's so good to be with you. And we're one of the largest individually organized groups of apartment owners in the state, and we're here to help you in so many different ways. We have the new updated forms. There's so many different things you can call in. And one of the other things that I wanted to mention today that we don't mention that often is that we do have a debt reporting service, and you can do that, use that if you are a member, and you can report debts once they are out of the of your building. And so go ahead, use that service. We'd love it. And we've had lots of great live stream content. A couple weeks back, we had one about SB9. You'll definitely want to catch that, and it just unlocks a lot of new investment potential. Everything we do here, we're wanting to keep you in the know. And so one way that you can help us help you stay in the know is if you sign up for the e-newsletter. You can go to aoausa.com, and at the very bottom on the right side, if you scroll all the way down, there's a place to sign up for the newsletter. That's free, and so you don't have to be a member for that, but we do definitely want to encourage you to become a member. If it's your first time, the whole year, you have a money-back guarantee for the whole year, so there's really nothing to lose. $79 now. When we get to next year, the price will go up. So you'll want to become a member now. And if you're a current member, we've had people call in. Very smart people are calling in and just upping their membership. Someone upped their membership last week for 6 years, and normally it's just a 3-year, but you can up it. And anyway, so that opportunity, we just want to give you fair warning that that's going to happen. And so definitely sign up and join and enjoy all the different resources and the benefits of being a member. And really, what we want to do is just give you ideas to help you make and or keep more money. We want to make, even though this thing is a headache with all this legal stuff going on, we want to make it as easy as possible for you. All right. If you're watching on AOAUSA.com, there is a blue help button at the bottom. It's blue. It's on the right side. If you click on that, you can put in your all of your questions. There's no way we're going to get to all the questions today, but we're going to take your questions the best that we can. And those chats, like I noticed someone put something negative about a specific political party. I think let's stay away from bashing that. Save your energy for other media, like go to the LA Times when they write an article that you don't like. Go ahead and troll there. Please don't troll here. Let's keep it positive. And you can vent your frustrations, or we can take it out on the policy, but let's stay away from people specifically. And anyway, so here we go, finally. So our speaker today, he grew up with his parents owning property. He is a landlord himself, so he's been involved in this industry forever. He's been doing evictions since 2000, so that's over 20 years of experience in evictions. And he is the owner and founder of the Brennan Law Firm. Oh, there goes his name. And so he is constantly serving in this industry. He helps answer questions for us all the time and brings clarity. He'll check our forms and make sure everything's good on our side. So he's really an advisor to AOA, and he speaks at the $1 million trade shows that we have, and writes articles at times, and just does so much for us and then also for others in the industry, even outside of us. So it's really a pleasure and an honor for me to introduce to you today, Michael Brennan.
I know this is live, so if I look like I'm looking down at my notes a lot. I am. There's just a tremendous amount of information that I need to convey, and I need to convey it very quickly. So I'm going to start today by saying I'll apologize in advance. I know that you guys are going to be, will they be seeing the slides? They will, yeah. So you'll be seeing the slides, and some of the font on the slides is very small, especially if you're looking on a computer monitor. So I'm going to offer you guys the slides. Anybody who wants the slides, I'll email them to you. You could just request that at info@mbrennanlaw.com. I'll say it one more time, info@mbrennanlaw.com. Just email us. You can do them right now. You can do it later. We'll get the slides out to you by the end of the day. I also want to say that it's important to understand that nothing I say today should be interpreted as legal advice. There are a lot of moving parts here. There's a lot of laws to consider. There's a lot of forms to consider. But more importantly, none of this stuff has worked its way through the court system yet. Across the country, we are seeing cases that have gone to the Supreme Court of many of the states. But in California, the laws I'm going to be talking about have not worked their way through the court system yet. They're convoluted, to say the least. So, as I said, it's not legal advice. I'm giving you my opinion about my interpretation of these laws and the many factors that go into it. Okay, so my job today is to convey some very convoluted laws to you guys in a manner that makes them as simple to digest and as easy to remember as possible. To do that, I'm going to be providing the information in chunks, or what I call key topics. So, for example, we're going to be talking about key laws today. We're going to be talking about the key dates you need to remember, the key forms that you need to remember, and then we'll talk about the requirements under AB 832. We'll talk about a couple new court proceedings that you're going to want to be aware of, and then we're going to have a slide called Prepare for Success. And what that is designed to do is tell you what you're going to need to have ready and present to the court in the event that you move forward with an eviction. And then we'll have a conclusion slide that kind of sums everything up. So to get started, we should be on the slide right now, and I apologize, let me get you there. There's the topics overview. Here's what we'll talk about today. Like I said, we'll do an intro, background and history. We'll do some key laws, key dates, notices, requirements, the new court procedures, prepare for success, and conclusion. Let's jump right into this. Essentially, the intro and the background and history, I'll blow through this stuff very quickly. Most of you don't need a reminder, but I'm going to remind you because it's important to understand where we came from to understand how to move forward. So as many of you will remember, March 2020, COVID hits, and the Governor Newsom issues stay-at-home orders. And as a response to those stay-at-home orders, the local municipalities issue just a patchwork of their own eviction moratoriums, in part so that the tenants wouldn't be evicted as a result of the negative economic fallout of COVID, and in part so that the tenants could comply with the stay-at-home orders. In April of 2020, we got AB 3088. That was the first eviction moratorium out of the state. And since I use the word state, it's important to understand today that there is a distinction. We'll go through the key laws in a second, but there's a distinction between state laws and local municipalities. There's also the federal laws, of course. We'll talk about that in a second. But while I'm talking today, very important to understand, AB 832 is a state law. And while it is a blanket law that lays over the prior laws, AB 3088 and SB 91, what is really key is going to be your local moratorium. So I will touch on that as we go through, but April 2020, AB 3088 comes out. First eviction moratorium out of the state. Same time or a little bit before the municipalities start putting out their eviction moratoriums, and it becomes this patchwork of laws that becomes very difficult to navigate. Nobody really understands what they can do, what they can't do, what they're prohibited from doing, what will result in a fine from a municipality, what would result in a dismissal of any eviction that gets brought. And then in September 2020, we get SB 91, which is essentially an extension of AB 3088 with some tweaks to it. Then in October 2021, we get AB 832. That started just a few days ago, October 1st, and that's where we are at today. So I'm going to go through these laws in a little bit more detail. Again, what I'm laying right now is the groundwork for you to understand how we got here and what you need to do to move forward. On a federal level, the United States government, we came out with two laws, the CDC moratorium and the CARES Act. The CDC eviction moratorium has been overturned twice now by the Supreme Court of the United States. So that is gone. It no longer exists. There's no CDC order anymore prohibiting evictions. So in a sense, that one has expired. But I want to make it clear that, well, I'll come back to this later. The other laws that are in place right now have not yet expired. You keep hearing that. The eviction moratoriums are expiring. They're not expiring. They're being overlaid by AB 832. They are still in place. But as far as the laws are concerned, the CDC has expired. The CARES Act, which was another federal law, for a large portion of it, has expired. To a large degree, has expired. But there is a component of the CARES Act that is still in place. And what I mean by that is, if you have a tenant makeup, if you're receiving tax credits from the federal government, if you have a tenant makeup that's receiving vouchers under the federal government, or if your loan on your property is backed by Freddie Mae or Fannie Mac, there's a portion of that CARES Act that still applies to you. And we'll talk about that in greater detail. But essentially, there is still a 30-day notice to quit that has to be served in conjunction with the 15-day notices under AB 832. But again, it's for a narrow set of property owners. It's basically properties that are associated with the federal government. Then on the state level, like I said, we had AB 3088, COVID-19 Tenant Relief Act of 2020. What that really did was it set up two distinct time periods. It set up the protected time period, which ran from March 1st, 2020 through August 31st, or August 31st rather, of 2020. And then, so in that time period, if you served a notice and a tenant returned the declaration for any rent that accrued in that time period, you can never evict that tenant. That's the protected period. That hasn't changed at all. Through AB 3088, SB 91, and even AB 832, that remains in place. What has changed that came out under AB 3088 was, I said there's two time periods. There's the protected time period from March to August 31st, 2020, and then there's the transition period. Initially, when that came out, that was September 1st, 2020 through January 31st, 2021. That was extended a couple times. We'll talk about that as we keep moving on. Basically, what AB 3088 did was it set up a new notice. It's a 15-day notice, a declaration that you had to give with the 15-day notice, and it set up those two time periods, and it told you what you could and couldn't do depending on what period of time you were seeking unpaid rent for. Then we got SB 91 that came out. That was called the COVID-19 Tenant Relief Act. A lot of people call that CITRA. And that expanded AB 3088, and it created new 15-day notices, declarations of COVID hardship, and what I call these informational notices that had to be served by specific dates. We will talk in greater detail about these notices. There's a multitude of these notices, how they still apply, whether they still apply, what you need to do if you haven't done it already, and how they interact with AB 832, but we'll talk about that a little bit later. After SB 91 came AB 832, and what that does is it maintains all the notice requirements that existed under AB 3088 and SB 91, and it actually layered on top of those new notices, we'll talk about that, and new requirements before you can get the court to issue a complaint, and new documents that the landlords will have to sign. So those are the key laws that came out on the state level. And obviously AB 832 is the most recent one. That's the one that you're going to care about quite a bit more. And you will care about as far as implementing it effectively. Then, like I said before, the key to understand here is the local moratorium's control. So you've got the federal laws we talked about. You've got your state laws, which apply to every single property throughout the state. And then you've got your local moratoria, which, in a sense, overlay on top of the state. So what you can and cannot do is not necessarily determined by AB 832. It's very likely that it will be determined by your local moratorium. And so I can't emphasize this enough. You have to know the local moratorium for the city in which your property is located or the county in which your property is located. Because I'm down here in Southern California, I'm well versed in the Southern California moratoriums, and I know I'm going to use the city of LA contrasted against the county of LA sometimes as an example, but these examples would apply whether you're up in Northern California or down in Southern California. the point I'm trying to make is know your local moratorium and know which one controls when. So having said that, let's keep moving on. It's important, one message that I want to get across right away is that it's very important to understand that each one of these state laws, AB 3088, SB 91, and AB 832, have very specific language in them that spells out the legislative intent. And it is very clear that the legislative intent, in fact, it states this almost verbatim, the legislative intent is to have all of this unpaid rent that came due during the COVID period, regardless of when during the COVID period, they want that all dealt with and resolved through small claims court. They do not want tenants to be evicted for any of this debt that came due as a result of COVID or remains unpaid as a result of COVID. So while the tenants are responsible for the debt and you will be able to recover it, you're going to have to jump through these hoops. And you should keep that in mind as I'm talking about these laws and these additional court appearances. Keep in the back of your mind that that is the goal. The goal is to structure this so that as few tenants as possible are evicted as a result of the COVID debt, and as many tenants as possible are assisted, and in a sense, the landlords are assisted as well, through these rental assistance programs. So having said that, let's jump into we've talked about the key laws now. Let's jump into these key dates. And for many of you, you know these key dates, but again, they become very important. So March 1st, 2020 to August 30th, 2020 is that protected period I talked about. Provided the tenant returned a declaration of COVID hardship after you serve that notice within that 15-day period, they can never be evicted for that unpaid rent. You will have to seek that through small claims court. If they did not return that declaration, you could file an eviction today. But again, my experience with my clients is that most of the tenants returned that declaration of hardship. And so, as I said, you can never evict them for that. You won't want to file an unlawful detainer case based on that unless they didn't file the declaration. You will have to seek that in small claims court. And we'll talk about the small claims court date in a second. The next key date you want to remember is that September 1st, 2020 to September 30th, 2021. So that's a 13-month period called the transition period. During that period, provided the tenants returned, they had to do two things. They had to return that declaration of COVID hardship, and they had to pay 25% of the unpaid rent that you demanded in that notice on or before September 30th. If they failed to do either one of those, you actually could have already filed an eviction. If you have not yet filed the eviction and they haven't done that, please feel free to call my office. We're happy to help you with that. But if they've done both of those, they returned the declaration and they paid you the 25%, then they will not be able to be evicted at any time, provided they continue to follow the law. Now, what does it mean by continue to follow the law? There are some repayment periods that I'm going to talk about later that are the key dates. So the next key date that you need to recover is called the recovery period. I apologize. You need to remember is called the recovery period. And that goes between October 1st, 2021 and March 31st of 2022. And I ask you to excuse me for a second. The screen keeps transitioning between me and the slides. If we could keep the slides up, I would appreciate that. That would be great. It really helps with my vision. So October 1st, 2021 and March 31st, 2022, that's when AB 832 is in effect. And in this period, the tenants, there's a lot of changes that have taken place. And this is why people are saying, well, the eviction moratoriums have expired. No, they have not expired. But here's the changes that took place. As of October 1st, the tenants are now responsible for 100% of the rent again, and they're responsible for that on the day it's due. It's not pushed off 6 months, 12 months, 18 months. They are responsible for the rent on the day it's due and 100% of it. Also, as of October 1st, there is a new 3-day notice that has to be used where your tenant doesn't pay that rent. And there's a lot of procedures we'll talk about how to use that notice, with the timing of the notice. It's not really a 3-day notice because you have to wait a certain amount of time before you can do anything about it. But that is, they've gone back to, they're transitioning back to a 3-day notice with AB 832. Under AB 3088 and SB 91, there were what we call an extension of the just cause provisions of AB 1482. So many of you remember, prior to COVID, we had just come out of AB 1482, which was the statewide rent control initiative. And while there's a bunch of civil code sections that fall under AB 1482, I'm not going to get into that. I'm just going to call it 1482, and that means the statewide rent control. Under statewide rent control and the statewide just cause eviction control, there were a lot of properties that were exempt from the just cause eviction. For example, a single family home was exempt in most cases, depending on how it was titled, it was exempt. Under AB 3088 and SB 91, those properties were no longer exempt from 1482's just cause eviction. So for example, under those laws, you could not evict a tenant for owner occupied. You could not evict a tenant for just a 30 or a 60-day termination. And it didn't matter what type of property you were in. Even a single family home that normally would have been exempt was now not exempt under AB 3088 and SB 91. Well, AB 832 went into effect, and it basically allowed those requirements. It allowed those exempted properties to go back into an exempt status. So you are, under state law now, again permitted to terminate the tenancies. You don't need the just cause component as long as, and this is key, you have to look at your local moratorium. So while AB 832 allowed those just cause requirements to expire, your local moratorium may still have the prohibitions against terminating tenancies for what we call no fault. For example, owner occupied, or you want to take the property off the market. Again, to give you an example, the city of Los Angeles, even though the state law has now removed those prohibitions, the moratorium in Los Angeles still prohibits you from terminating a tenancy for owner occupancy, or terminating the tenancy even if it came to the end of its lease. So you have to look to your state law to determine what it says as far as just cause evictions. But as far as the state law is concerned, the extension of those is now expired. And if your property was exempt, for example, if your property is less than 15 years old, you're exempt from the state's just cause eviction requirements. And under AB 832, that would be the same. Now, AB 832 does implement some new eviction procedures that need to be followed, both before you file your eviction and during the eviction. And it's got a bunch of new eviction forms that need to be implemented and used before you file your eviction as well. Most of that, I'm going to say, you shouldn't really worry about right now. My office has the procedures. We know what they are. My office has the forms. We're going to use the correct forms. So, and I think, probably most landlord-tenant firms out there understand the procedures and have the forms in place. If they don't, again, we're happy to help. But the point is, there are these new requirements, but you shouldn't let that overwhelm. We're going to talk about them. I'll explain to you what they are, but don't let it overwhelm you. We've got the procedures in place, and we've got the forms you'll be using. And then finally, what I want to talk about is the fact that under AB 832, and there's a little confusion and disagreement among attorneys right now as to whether what I'm about to say is accurate or not. But so far, from what I've seen under AB 832, there is a class of tenants called new tenancies. And so a lot of these laws under AB 832 and AB 3088 and SB 91 will not apply to a new tenancy. And a new tenancy is defined as a tenancy that went into effect as of October 1st, 2021. Now, what is not a new tenancy would be if you have a tenant in an existing unit prior to October 1st, 2021, and all of a sudden you sign a new lease with them as of October 1st. That's not a new tenancy. They've been at the property, they've been in that unit, you had a lease, it's just a new lease. I think where there's a gray area, and my interpretation of it would be that if you had that same tenant and they moved to a new unit, then there's an argument, and you have a new lease with them in that new unit, then there is an argument that that is a new tenancy because they've taken possession of a different unit. Certainly what would be considered a new tenancy would be somebody that you've never rented to in the past at that building or in that unit, and as of October 1st, they sign a new lease for one of your units. That would be a new tenancy, and these laws that I just addressed would not apply to them. Again, you're going to have to go by what's in your local moratorium for details, but that's the key date for October 1st, 2021 through March 31st that's when AB 832 is in effect. Now, I want to emphasize that it does run through March 31st, 2022, And as it's written right now, as of April 1st, 2022, we would then go back to pre-COVID notices, pre-COVID laws, etc. But two things to think about. First, AB 832 could easily be extended. It would depend on, my guess is it would depend on things like the Delta variant, number of cases, number of deaths per cases going up or down. And so keep that in the back of your mind. This could easily be extended. And then the second thing to think about that date is also be aware that as of April 1st, all the local municipalities are again able to create, extend, modify all of their local moratoriums as well. So just because AB 832 runs until March 31st, 22, does not mean that we're out of the woods. And again, I know they keep saying these have expired. Hopefully, what I will say is, while they haven't expired, we still have all these laws we have to comply with. We are starting to see light at the end of the tunnel. In the last couple months, we've seen quite a few cases across the country rule in favor of the landlords. There's a Supreme Court case out of New York that what the ruling was in that is that there's a portion of their moratorium that is unconstitutional, specifically the portion that states that the tenants can self-certify that they've been impacted by COVID. That portion was deemed to be unconstitutional because it denies landlords due process. In other words, if the tenant is going to claim that they have been impacted by COVID, if the landlord isn't allowed to make them prove that, then the landlord is being denied due process. So that portion of that moratorium is illegal. It's unconstitutional. It can't be enforced. The reason I bring that up, and I say that's a glimmer of hope, is because the city of LA, for example, LA County, they both have the self-certification components to their moratoriums as well. So as these cases work through, we are starting to see favorable rulings. As I said, the Supreme Court of the United States ruled in favor of landlords on the CDC's moratorium as well. And there's several other cases as well across the country that ruled against the CDC order. So we are starting to see the light at the end of the tunnel. The challenge is that with evictions, you get used to what I'll call a shortened time frame. Those are special procedures. They run on a calendar that is not the same as a civil lawsuit. And so I know most landlords out there would disagree that they're fast, but compared to a regular civil action, they're very fast. Regular civil action takes anywhere between 12 months or more, typically 12 to 18 months to work its way through to a judgment. And that's what you're starting to see with these cases. It's been 18 months since COVID hit. There have been lawsuits filed all over the place, and they're starting to work their way through federal courts, through state courts, through the Supreme Court of the United States, and we are starting to see these favorable results. So while there is light at the end of the tunnel, I go back to we're not out of the tunnel yet in California. We've got that March 31st deadline or expiration date for AB 832. At that time, local moratoriums can do whatever they want again, according to AB 832, and your local moratorium may still be in effect right now, like it is for many of us down here. So the next key date that is important, let me change the slide for you guys, is November 1st, 2021. That is an important date for you guys because that's when you can file your small claims and civil actions to go after the unpaid COVID rental debt. So where would that apply? I'm not going to get into the specific dates about repayment plans under the local moratorium yet. I discussed that later. But if you have a repayment date under your local moratorium, my interpretation of this is that you would have to adhere to that date before you could file a small claims action because that date hasn't expired yet. And so in that situation, if you went into small claims court on November 2nd, for example, and the repayment period, I'm just making this up, let's say the repayment period is May 1st, 2022 to May 31st, 2023, I could see a judge saying, well, their repayment period hasn't expired yet, so you're premature in your case. You're not allowed to bring this case. I'm going to dismiss it without prejudice. So why does that November 1st date then become important? Because in my reading of the laws, if you have a tenancy that was in place, but the tenant has already vacated and they owe you unpaid COVID rental debt, my interpretation of the law is that at that point on November 1st, you would be entitled to go after them because they're no longer entitled to the tenant protections under all those state laws and local moratorium. with regard to you because they are no longer your tenant. So November 1st, keep that date in mind. Of course, you're always able to enter into a repayment agreement with the tenant, regardless of the November 1st date or regardless of the repayment period in any local moratorium. So I encourage you guys to start talking to your tenants now about a repayment plan, and maybe you can actually speed up the time period if it's put in writing. The time period, you can speed that up in comparison to what's in your local moratorium. The next most important date is March 31st, 22. And again, that's when AB 832 expires, and that's when the notices and procedures go back to, theoretically, they go back to California law pre-COVID. So 3-day notices to pay rent or quit, 3-day notices to cure covenants or quit. However, again, I'm going to keep reminding you, look to your local moratorium. And this is probably as good a place as any to say emphatically right now that I really strongly encourage you guys not to try to navigate this yourself unless you are an attorney or unless you've been doing this forever and you understand this stuff. Anybody who's trying to navigate this themselves, who is not an attorney who practices in the landlord-tenant arena, is asking for some trouble. So whether it's some other firm out there that does landlord-tenant work or my firm, you need to align yourself with a landlord-tenant attorney who is just immersed in all of these laws, understands the notices, understands the requirements, understands the dates, understands the timing, and understands how to guide you or be your guide through all of this stuff. So again, March 31st, 2022, the notices are supposed to go back, but if you've got a local moratorium, they probably won't be going back, so talk to your attorney. All right. The next key date is May 1st, 2022 through May 31st, 2023. And I was just alluding to this a second ago. The reason that date is important is in this specific area, AB 3088, SB 91, and AB 832 all preempt the local moratoriums. And what I mean by preempt is they control. AB 832 now controls the local moratorium as far as when the tenants have to repay the unpaid COVID debt. So let me give you an example where the tenant owed you money for both a protected period and that transition period. You served 15-day notices for both. They returned the declarations for both, and they have now paid you the 25% that they owed you on or before September 30th, 2021. Okay, so they still owe you 75%. When does that become due? Well, it will depend on your local moratorium. What all of the state laws said, AB 3088, SB 91, and AB 832, all of those had a provision in there that said whatever the local moratorium said as of August 19th is basically what they're stuck with. If it had a repayment start date that was earlier than May 1st, 2022, then that date's going to remain in place. So let's say it said April 1st, 2022, they have to start paying. Regardless of the local moratorium, whether it's changed, extended, modified, it doesn't matter. The state law controls on that, and it will remain April 1st, 2022. But if your local moratorium had a more nebulous date, like City of LA, County of LA, many other cities around here, where it said the repayment date starts at the end of some period after the expiration of the local state of emergency. So, for example, the City of LA says the repayment period starts for 12 months after the expiration of the state of emergency. What does that mean? When is the state of emergency going to end? And again, I remind you, it says the local state of emergency. So what that means is 12 months after the city of Los Angeles expires its local state of emergency or rescinds it or allows it to expire, that's when their repayment period may end or start. But under AB 832, what that says is that no, if you have an undefined repayment plan that starts at the end of some local, at the expiration of some local state of emergency, then that in no event does the tenant have beyond May 1st, 2022 to start making payments. So they have to start making payments by May 1st, 2022, and the payments have to be done by May 31st, 2023. So that's a 13-month period in which they're going to be allowed to repay any of that debt. So that, again, that's the May 1st to May 31st, 2023, and those are your key dates that you need to remember. And again, if I'm going too fast, I'm trying to slow myself down here, but if I'm going too fast, Don't stress out too much. Just send an email to info@mbrennanlaw.com, and I'll send you these slides, and it's all in there. So now we're going to move on to the key notices and what you need to remember about these notices. First of all, a defective notice is a complete defense to an eviction. If you have a defective notice, even if the tenant or the tenant's attorney does not bring it up that it's defective, the court always has the ability to read your notice, determine it's defective, and dismiss your case. So again, as I just got done saying, as you're going to see as we walk through here, there are a lot of notices, and there's the language changed in each notice. And there's these informational notices, there's 15-day notices, there's a protected period, there's transition period. If you are trying to serve your own notices, I think you're doing yourself an injustice. Please contact an attorney that does this every day, inside and out, understands this stuff, and allow them to draft the notices for you so that you have the best chance of it being a successful case for you. So we're going to start off talking about pre-COVID notices because it is important. I still have cases that are working through the court system right now that we filed before COVID hit, probably, late February or sometime in February. Those cases were filed because the tenants owed rent pre-COVID. So what do you do during this pre-COVID period? What do you do if the tenant owed you February's rent, but you hadn't served a 3-day notice when COVID hit and all of a sudden everything was put on hold? Can you still serve a notice for that rental period? And under normal circumstances, the answer would be no, because a 3-day pay rent or quit notice pre-COVID, the code specifically says that you can only go back 1 year seeking that unpaid rent. And there's accounting methods you can use to move that forward and move it around and play around with that. But putting those aside for a second, a tenant that owed you rent from February of 2020, technically, under normal circumstances, you would not be able to serve a 3-day notice for that rent right now. However, there's a law that says it's called a tolling period. If your property's in a municipality that prevented you from serving those notices, for example, City of LA prevents landlords from serving non-payment of rent notices during the moratorium. If you are in that type of a moratorium jurisdiction, that time period is tolled. So as soon as you are able to serve a notice, you could technically go back and serve a 3-day notice for that February's rent and bring your case based on that. I don't necessarily recommend that you do that for a lot of reasons. Judges may not understand that. You might be, losing an opportunity to get a lot of rent and get a judgment, a much larger judgment amount. So it may make sense in certain circumstances. In some circumstances, it might not. Talk to an attorney. But that is what's going on. So the City of LA, for example, or any other city that's got that language in there that prohibits you from serving a notice, you can still go back when that moratorium expires. You can go back and serve that notice for that 3-day period. If you're in a jurisdiction that did not prohibit you from serving notices, that rent that accrued more than a year ago, you may not seek that in a 3-day pay rent or quit anymore. You would have to seek that in small claims. Now, there's a distinction between the 3-day pay or quit and the 3-day cure covenants. And so, for example, if a tenant owed you utilities, let's say they were responsible for utilities under the lease, and they owed you utilities pre-COVID, that code does not have a limitation of 1 year. The limitations on that would be 2 years on an oral contract or 4 years on a written contract. So theoretically, if they owed you that money and you were not in a jurisdiction that prohibits serving notices right now, you could go ask for that money, that pre-COVID money right now. So that's the pre-COVID notices. Then we move into the 15-day notices under statewide COVID moratoria. And I'm not going to get into the details of these. I'm just going to walk you through the dates. There was a 15-day notice for that protected period. I told you that runs from March 1st, 2020 to August 31st, 2020. Then there's a 15-day notice for the transition period between September 1st, 2020 to December 31st, 2020. Then there was a 15-day notice for the transition period that ran from, I apologize, first transition period was September 1st, 2020 to January 31st, 2021. Then there was a second transition period that ran from February 1st to, I believe it was June 30th, 2021. Then there was a third transition period that ran from July 1st to September 30th, 2021. So there's 4 notices I just talked about just in the last year and a half. Each one of them has different language, and they're very similar when you look at them. You have to actually read through it. I use a ruler to read through it to make sure I don't miss any language, to make sure that I'm serving the right notices. On top of those 15-day notices, there are informational notices. I call them tenants' rights notices. Some people call them informational notices that had to be served with those 15-day notices. There was an informational notice that had to be served on or before September 30th, 2020. There was another one that came out that had to be served on or before February 28th, 2021. Then there was a final one that came out that had to be served on July 31st, on or before July 31st, 2021. And the language of the law says those have to be served either they had to be served by those dates, or they had to be served simultaneously with the 15-day notice. What the law does not talk about, and it's unclear right now, is what if you didn't serve those notices on time? Can you serve them now? My practice is that, yes, we serve those every single time we serve a notice. We still serve those informational notices because the law is unclear about that. It does not say that if you didn't serve it by that date that you've lost your case, or that you can't bring your case, or that it's a defective notice. It doesn't say that. So, but you can see how the notices are stacking up and becoming complex. On top of the informational notices, you had to serve this tenant's declaration of COVID hardship, and that had to be served with every notice. And going back to the moratoriums, prior to the state laws coming out, the moratoriums had additional notices that you had to serve that had their own specific language. So you need to be aware of those as well. So again, as you can see, just trying to figure out what notices you had to serve, when they had to be served, if they had the right, it can become very, very confusing. And again, that's why I recommend you don't try to navigate this yourself. And then the final notice that you need to be aware of, and I think most landlords out there are the happiest with, is as of October 1st, we have a new 3-day notice that has to be served. It's not the old 3-day pay or quit. It is a new 3-day pay or quit with statutorily required language, and it's got to be in a specific font, and it has to have specific language. It's got to state the prior 3-day notices did not have to state the specific date on which payment of rent became due. It just had to state the amount that came due. These new notices, they do have to state the date it became due. Like I said, it's got to have that language in it. They've got to have the telephone number and the web address of what they call the pertinent government rental assistance program. Candidly, it doesn't define, I couldn't find a definition on that. To the best of my knowledge right now, that is housingiskey.com, and there's a phone number. It's in the slides if you want it. You just ask for the slides, it'll be in there. But there's this new notice that has to be served, and there's different ways you could serve this new notice. You could serve it after you fill out the application. You could serve it before you fill out the application. I've gone through it with the eye of a landlord and said strategically when's the best time to serve it. And from what I can determine, it actually makes sense to be served the 3-day notice, to serve that 3-day notice after you've applied for the rental assistance funds. And we'll talk about whether that's mandatory or not in a second. But from what I can tell, if you strategically, to make this flow as smoothly as possible, you want to apply for the government rental assistance funds before you serve your 3-day. And since we're talking about applying for the government rental assistance funds, in the prior laws, this was never mandatory. And I know there were a lot of landlords out there that did not want to participate in those programs. And this law, AB 832, does not state that it is mandatory. However, from a practical standpoint, it is definitely mandatory, both from an eviction standpoint and a small claims action standpoint. In an eviction, you cannot get a summons issued now unless you sign a verification that you've done certain things and you meet certain procedural requirements. Well, one of those is that you've applied for the government rental assistance funds. In the small claims action, if you just said, oh, I'm going to let them stay and I'm going to go after this in small claims court, then there are documents you need to fill out in the small claims action as well. And the small claims action actually allows the judge to reduce the award amount based on how much the tenant would have qualified for had you applied for the funds. So like I said, from a legal perspective, you're not required to fill out these applications and participate in this program, but it really doesn't make sense why you wouldn't. One, AB 832 bumped up the assistance amount to 100%, and two, you can't file an eviction, and you could file a small claims action, but the judge could reduce it if the tenant qualified for those loans. So it doesn't make sense not to do it. Let me just take a look at my notes right now and make sure I'm not missing anything. And I am not missing anything. We can move on now. So those are your effective dates and your effective notice, or your key dates and your key notices. All right, so let's jump into the new requirements under AB 832. This AB 832 applies to all evictions filed between October 1st, 2021 and March 31st, 2022. We've talked about that a little bit. That does not mean that the requirements of AB 3088 and SB 91 are no longer necessary or are out the window. It's not true at all. Those two laws are still on the books. They are still in place, and you still need to comply with them. Where that would become important, I have clients that call me every day, and when I ask them, well, have you served any notices yet? They say, no, I haven't served any notices. I figured I couldn't evict them, so what was the point? But now I see this new law and I want to serve these notices. So if you're going to be looking for rent that accrued during those other periods, the protected period and the transition period, you still have to apply SB 91 and AB 3088. So AB 832, like I said, it applies to evictions being filed between October 1st, 2021, March 31st, 22. And it is based on non-payment of COVID rental debt. So that's including unpaid rental periods for March 1st, 2020 and September 30th, 21, and anything in between October 1st, 21 and March 31st, 2022. So like I talked about before, the language of the law indicates that this applies to these new tenancies. And there is a difference of opinion right now. I'm hoping to unpack this over the next couple of days about whether the 3-day notice would have to be used, the new 3-day notice under AB 832, whether that would have to be used in a new tenancy or not. My opinion previously was that no, if it's a new tenancy, you could technically go back to your old 3-day notices, but as many people have pointed out, there's a different interpretation now, so stay tuned on that. That'll unpack over the next couple of days, and I will be putting out a newsletter on whatever it is I find. Another key requirement and procedure is that as I just said a minute ago, I would encourage you to go to housingiskey.com right now and apply for your rental assistance funds. There is a provision of the law that states the landlord has to wait 20 days after the latter of either submitting the application or serving the new 3-day notice or your 15-day notices. You have to wait 20 days from the later before you can file your eviction. So in other words, if you file your application right now and get that underway and you serve your 3-day tomorrow, there's a 20-day window from tomorrow. So the day after tomorrow would actually be day 1. There's a 20-day window that you cannot file your eviction. And you're waiting for one of a couple things to take place in there. You're waiting for either a email to come back to you from Housing is Key saying, yes, your tenant is qualified and we're going to be distributing funds. Or you're waiting for an email to come back saying, no, this tenant does not qualify. That would be called a final decision. And that becomes important. So the 3-day notice that's why I said it's not really a 3-day notice. The 3-day notice that we're all so happy about is really essentially a 24-day notice, because you still have to wait the 20 days. Under AB 3088 and SB 91, the 15-day notices didn't include weekends or holidays. That turned out to be roughly a 21-day notice. Well, the same thing here. The 3-day notice is turning out to be a 23 or 24-day notice, depending on how you calculate it, possibly even longer if weekends and holidays are in there. And so the 3-day notice really doesn't change a whole lot. Going back to that final decision, like I said, the 20-day period is specifically designed to allow the tenant to apply for the funds. So what happens is you apply for the funds, you get your email confirming that you've filled out the application, and then if you have the tenant's email, they're going to send that tenant an email as well. If you don't, I'm assuming they're going to mail the tenant some notice saying, hey, your landlord has applied for the rental assistance funds. Please log on, please apply, etc. That's what that 20-day waiting period is for, is to allow the tenant to do that. So like I said, while it doesn't say in the law that it's mandatory that you apply for the funds, from a practical standpoint, it is mandatory, and the sooner you do it, the better. I say you do it before you serve your 3-day notice. Other people disagree. It's ultimately up to you as the landlord how you want to proceed. We do it before we do the notice. After the notice is served, and you wait your 3 plus 20 days. Well, let's talk about that 3 plus 20 day period. If you get a notice from housingiskey.com prior to the 20 days that says, hey, your tenant did not qualify, you're not required to wait the rest of that 20 days. You could file your eviction right there. And just a little bit of insight to manage expectations here. Don't believe that just because you file an application, every tenant out there is going to qualify for the rental assistance funds. That's not accurate. The tenants right now that will qualify are those tenants who are at or below 80% of the mean income for their area in which the property is located. So if you're in a high income area, your tenant has to make 80% or less than the median income in order to qualify. And so if your tenant doesn't make that amount, they make more, even if they're at 90% of the median income, they will not qualify, and you will get an email saying, hey, the tenant didn't qualify. In that case, all of the rules that we've just talked about important dates to know, small claims actions, how do you repayment periods, all of those will kick in. But the key to note is that if you get that denial, that final decision that says they didn't qualify, you don't have to wait the 20 days. You can file the eviction right away. And we'll talk about some what I'll call second chances in the procedure, the new procedures that came out under these laws. So under like I said, under AB 832, if you file your application, then you file your 3-day, you get a notice saying that they've been denied, or you don't hear anything in 20 days passes, you're going to file your summons and complaint. So now we're going to be talking a little bit about the courts and what the courts are requiring, just so you understand the procedures that my office, or if you're doing it yourself, you're going to have to go through, so you understand why some of your cases are going to be delayed. There's no question about that. This is not 2.5 years ago, pre-statewide rent control, pre-COVID, where the cases moved slower than they used to, but still pretty quickly. You are going to experience a lot of delays moving forward, at least in my opinion, for the next 18 to 24 months. But if I walk through this stuff and kind of give you a heads up as to what is required of you, then you'll understand why this is taking a lot of resources and a lot of time. So to file the summons and complaint, there are 3 new requirements, essentially. There's new allegations and documentation that need to be submitted with the complaint. There's a new mandatory statement that the landlord is going to have to sign, and there are landlord's verification of certain facts that they will also have to sign under penalty of perjury. I wouldn't stress this too much. Like I said, my office has the procedures. We have the forms. We've got a procedure in place that makes it as quick as possible from the time you get those documents from us to you get them back to us, that we can turn around and get them filed with the court. But I'm going to go through them just so you understand what is required of you, just so if you do use my office and we're telling you, hey, we need this and we need this and we need this, you don't get frustrated with us. None of this is coming out of my office. It's all coming out of the judicial council and the court system. And then finally, in addition to those 3 new requirements I just talked about, even if you get all the way through your case or it doesn't go to court because the tenant never filed an answer, you get a default, there's another verification that the landlords will have to sign before the court will even enter a judgment. So there's essentially 4 or 5 new requirements, which will all cause the delay, and a couple new hearings, which might even cause some more delays. Well, let's talk about the 3 new requirements. New allegations and documentation. The landlord is going to have to attach documentation that establishes the landlord made a good faith effort to do one of 2 things. Either they made a good faith, or one of 3 things. They made a good faith effort to investigate whether the tenant is eligible for the rental assistance funds. They made a good faith effort to seek government rental assistance through housingiskey.com, for example. And or they made, well, it's not and or, it's and. I apologize. It's or only. Or they made a good faith effort to cooperate with any efforts by the tenant to have the rent paid by a third party. So let's say the tenant didn't go through Housing is Key. I know that United Way, for example, was issuing landlords checks on behalf of tenants. So if the tenant came to a landlord and said, hey, it's not housing is key, but United Way wants to pay a portion of my unpaid rent, the landlord has a good faith effort to cooperate with the tenant in that, and you are going to have to attach the documentation for that. Like I said, we've got all that set up for you. And then there's a mandatory statement that the landlord's going to have to sign, and it will be submitted with the summons and complaint. The landlord's going to have to show one of two things happened. We kind of alluded to all of this just now. Either they applied and received that final decision indicating that the tenant was denied because they didn't qualify, or they applied and all of the following elements are true. So 20 days has passed and the landlord's received no notice or verification that the tenant has applied from the rental assistance program. And the landlord received no communication from the tenant that they've applied. So again, you're going to have to attach a document to your summons and complaint that states all of those things. Hey, I applied, 20 days passed, I got a denial or a final decision that's a denial, or I applied and nothing's happened, the tenant hasn't complied with their end of the deal, they haven't submitted their application, or that I've received no notice whatsoever. So you have to sign a document that states all of that. And that's the mandatory statement you've got to sign as well. Let me just check real quick. I want to make sure I'm not missing anything. We've basically covered everything. I want to talk to you real quick about that final decision I keep mentioning. You will get an email. If they qualify, they qualify. That in a sense is a final decision. Or you'll get an email saying they don't qualify, and that is also very likely going to be the final decision. What will not count as a final decision, so if you're reading that email, any of these things I'm about to mention is not a final decision. So for example, if the application was rejected as incomplete, that's not a final decision. So let's say the tenant does actually hop online and they fill out their application and they do not submit the necessary documents or statements in lieu of the documents, that application is now incomplete and it will eventually be rejected, but that will not be a final decision. It'll be just a kind of a temporary setback for you. Another thing is a notification that the application is temporarily pending further action. So they submitted their documentation within the time period and the rental assistance program is going through it, and maybe they're asking the tenant for additional information or additional documentation. That application will be deemed pending. And in that 20-day period, you will not get a final decision. You will get an email saying it's still pending, but that's not a final decision. I couldn't file an eviction on that. And finally, you could get a notification that either that you or the tenant filed an application with the wrong agency. And like I said, right now, housingiskey.com is the only agency that I know of that everybody has been instructed to go to. So I think what that refers to is housingiskey.com may send you an email saying, okay, this is who will be distributing your funds. This is the pertinent government rental assistance program. But your first step is go to housingiskey.com. So if you get an email saying, hey, you applied at the wrong place, or the tenant applied at the wrong place, that would not be a final decision either. So that's what is not a final decision. Like I said before, a final decision is basically you getting an email saying, hey, your tenant doesn't qualify. That's our final decision. Or they did qualify and you should be receiving the funds very quickly. I don't know if it's true, but I heard just yesterday that the city of Los Angeles is being prioritized for receipt of these funds. I speak to clients every day. Very few of my clients have actually received money. A few of my clients have received a little bit of what they've applied for. They've received the email saying that the tenant has been approved, but very few people have actually received the money. But like I said, I just heard yesterday in the city of Los Angeles that they are being prioritized for the receipt of these funds. It's not all that surprising. You've got over $5 billion up in Sacramento that's got to be dispersed throughout these cities and counties. And, you know, I don't want to sound cynical, but bureaucracies are rarely efficient and good at doing things like that. We've been in COVID now for 18 months. We've had funds available for probably, you know, at least 14, 15 of those 18 months, and they still had problems distributing those funds. So I don't anticipate it happening very quickly, but that's, you know, we'll see how it goes. In addition to your final decision, I talked about a verification that the landlord has to sign. that verification is signed under penalty of perjury, and basically what it says is before filing the eviction, the landlord submitted the application to the correct program. They're seeking the same funds in the rental assistance program that they are seeking in the summons and complaint. 20 days have passed since either they filed the notice to pay rent or they applied for the funds and they received from the rental assistance program no notice or verification that the tenant's been approved. But this key one, this last one, is the one I think will create the biggest problems. They also have to verify under penalty of perjury that the tenant has not communicated to them that they've applied for the funds. The reason I think that's problematic is a lot of tenants will tell you, yeah, I've applied for the funds. Whether it's intentional or mistakenly, maybe they applied to a city and that program no longer has the funds, and in the tenant's mind, they've applied for the funds, but they really haven't applied under housingiskey.com. And if they tell you that they've applied for funds, again, you're signing this verification that they have not notified you that they've applied for the funds, and you're signing it under penalty of perjury. So just keep that in the back of your mind. And then, as I mentioned before, even after all of this, after all this pre-summons and complaint documents you have to fill out, statements you have to sign, procedures you have to jump through, then you're also going to have to sign an additional verification at the end of your case before a judgment can enter. What that one is going to say is basically, I'm going to give you a short overview of it. Basically, you haven't received any funds because the court doesn't want you to obtain a judgment for, I'm going to use round numbers. The court doesn't want you to get a judgment for $10,000 and then get a $10,000 check from the rental assistance program. So you're going to have to verify again before the judgment enters. You didn't receive any funds. You haven't received a notice that you're going to receive any funds for any of the money you sought in the eviction, that the tenant didn't receive any funds, or that the tenant's not going to receive that, or that you haven't received any funds for anything that accrued after you filed the eviction. So again, the whole point of that is to prevent landlords from double dipping or gaming the system, getting a judgment, getting possession of the property, and then receiving those funds from the rental assistance program. There's also some findings that the courts are going to have to make. I won't get into a lot of the details. Let's just say they involve a lot of those requirements that I just discussed for landlords. Let's talk about the new court proceedings. This is where I say the tenant gets the second bite at the apple twice. And I know many landlords are going to hear this and say, well, you know, everything is stacked against us. I agree with you. It is. Everything is stacked against you. I go back to what I said at the beginning of the seminar where I said, remember, the legislative intent was spelled out. Rarely have I ever seen legislative intent spelled out as clearly as it was in these three laws. The whole point is to keep the tenants in their units during the pandemic and allow the landlords to recover the unpaid rent, but without an eviction. Either you get it through the rental assistance program or you get it through small claims or a civil action, you know, like a breach of contract action, something like that. The whole point is to keep those tenants in the units. So when you hear what I'm about to tell you, you say, oh, you know, they're just making it easier for the tenants. Absolutely correct analysis. So the first one is if you serve a 15-day notice, as I said, there's two things the tenant had to do. They had to sign or return a signed declaration to you saying they've been impacted by COVID, and they have to pay you 25% by or on or before September 30th, 2021. If the tenant did not return that declaration, let's not talk about the 25% because that date is gone. Let's assume they just didn't even pay you. If the tenant did not return the declaration and you file that eviction, this tenant is still permitted to go to court and file that declaration with the court within the summons period. The summons period, depending on how the defendant was served, if they're served personally, that summons period is going to be 5 days. If they were subserved, that summons period is going to be, the way the courts operate, that will be a 15-day period. Any time within that period, the tenant can go to court and file that declaration. If they do that, the court is going to hold a hearing, and the court is going to determine whether the failure of the tenant to return that declaration to you within that 15-day period was due to mistake, surprise, excusable neglect. There's several words that they use to say, hey, that, you know, the tenant just didn't do it and it's okay with us. If the court holds that hearing is going to be held within 5 days of the tenant serving that declaration to the court. If the court comes to the conclusion that the tenant didn't know, it was a mistake, they were confused, it was excusable neglect, let's say they had to somebody in their family died of COVID, for example, during that period, they had to return that declaration. The court will, if they make that determination, the court is going to dismiss your case with prejudice, because essentially they're going to say, well, the tenant has now complied. We're going to dismiss that case, and the landlord will have to go after that unpaid rent through the other channels, like the rental assistance program, et cetera. What was happening pre AB 832 or prior to October 1st is the court would just dismiss it, and they still had until September 30th. They've technically been in compliance, and they had until September 30th to pay that 25%. Since this went into place, we've had several judges where the tenant has filed the declaration, and the judge has said, no, you're not in compliance yet. I'm going to hold a hearing next week on this. You have turned in the declaration, but now I'm ordering you to pay the 25% within 5 days of this hearing. And so that's actually, the judges are actually helping out the landlords by that. They're actually ordering the tenant to pay that 25% that they probably failed to pay in the first place. If the tenant does not pay that 25% within those 5 days, now the landlord can move forward with their eviction. So you've got that first new hearing, I'll call it, where the tenant can actually go in. They failed to file their declaration. Maybe they failed to pay the 25%. Now they've got that second bite at the apple. Not every, you would think, depending on what jurisdiction you're in, a lot of the judges were dismissing the cases and saying, hey, they've done what they're supposed to, et cetera. Surprisingly, some of the judges were not. We had hearings where the judge said, I'm sorry, that doesn't, your excuse for not filing a declaration doesn't cut it with me. And they allowed us to move forward on those. So again, that's a ray of hope that we're moving in the right direction. So that's the first proceeding. If your case does get dismissed without prejudice, you get to bring it again. And then let's look at the situation where the court does not dismiss it. The court says, no, you missed it. You're exposed. You now have to go through with the whole proceeding. In that case, you're going to have your trial. The tenant will probably file their answer. The standard, just like a standard pre-COVID eviction, if they get a tenant's rights attorney, they're going to file their answer. They're going to hit you with discovery. They're going to make a jury trial demand, etc. The second hearing that is relevant for everybody to know, this is the one that comes right out of AB 832, is it's the hearing for the 25%. I just want to make sure I'm not skipping ahead of myself right here. I am a little bit, but it's okay. I apologize. It's not for the 25%. It's for what we call a motion for relief from forfeiture. So I won't go into the details of what forfeiture means. It basically means a contract's being canceled. If you do a normal eviction, there's two different judgments in an eviction. There's judgment for the possession of the property. Okay, you're getting your property back. There's also judgment for money. Either way, when that judgment enters, the court forfeits the rental agreement. So they canceled any agreement you might have had. The court, in this case, under AB 832, you can go through the entire case, and at any time prior to the lockout, and I mean any time, if your lockout is scheduled for 1:30 in the afternoon, the tenant could go to court that morning and file with the court a declaration. There's not even a specific pleading that they have to file with the court. It's simply a declaration. That declaration can say, hey, I've been approved for the rental assistance funds. And the court will pause everything. We call it a stay. The court stays the proceedings, they stay the lockout, but it's a pause. The court will issue an order stopping the lockout. The court will issue an order staying the court proceeding or the trial or the entire case, and they will allow that tenant to come back. They will set a hearing for 15 days down the line, and they will allow that tenant to come back within that 15 days to demonstrate that the landlord did in fact receive the funds. So again, just to reiterate, you can go through your entire case. Any time prior to the lockout, tenant can file this declaration that, hey, I got approved, and the court is going to pause that case for at least 15 days. And if the landlord receives the funds at that point, then the case will be dismissed. If the landlord does not receive the funds, then the court will continue that hearing for an additional 15 days. And there is no limit to how long they can do that. And again, you can see where this could be a way to game the system on the tenant's part. Hey, yeah, I got approved for the funds. It's just a declaration that they have to sign. Okay, we're going to have a hearing. When were you approved? Oh, I was approved just yesterday. Okay, great. We'll continue the hearing for 15 days. 15 days, the landlord comes back and says, I haven't heard anything. I haven't gotten a single penny. And the tenant says, yeah, they said they're mailing me the documents. I don't have an email. Okay, well, we're going to continue it another 15 days. At some point, eventually, the judge is going to look up and say, I'm just going to move forward. I'm going to allow this lockout to move forward, or I'll allow the case to go forward. But they can delay it for, I don't know how long. It doesn't really clearly say that in the law. So just be cognizant of that fact when you're moving through the eviction process, that there's these two hearings that can put you a step back. I will say, even in the area of California that I practice, I'm starting to get the impression that the judges are fed up with this whole situation themselves. They're starting to rule what I would say more in favor of the landlords. They're putting up with less nonsense from the tenants. So it looks like we're moving in a positive direction. So there is hope out there. All right, so I think I've covered. I didn't change my slides, and I apologize for that. But again, if you need the slides, just email us, and we'll be happy to get them to you. We talked about the 2 new court proceedings, and now we're on the prepare yourself for success. So I've basically covered a little bit. I've given you all the key notices, the key dates, the key provisions of all 3 of these laws: AB 3088, SB 91, AB 832. I've told you that it gets very confusing. Your notices have to be perfect. Every I has to be dotted. Every T has to be crossed. There's no question that this is you're dancing in a landmine field if you attempt to do this yourself. So what can you do to prepare yourself for success, whether you do it yourself or you hire an attorney? There's a lot of things you can do right now, but basically what I'll say as an overview is it's going to be your due diligence. Hopefully you've kept meticulous records during COVID. I have a lot of clients that pre-COVID, I was always telling them, hey, you need to keep better records, et cetera. Well, as time goes along, I've always said the level of due diligence required by landlords is just becoming more and more. And that's certainly true here. There's an incredible amount of due diligence. And as I said before, the slightest little mistake will cause your case to be dismissed, and you'll have to go about things a different route. So pull all your files for the tenants who have unpaid rent between March 1st and today. That's first. Pull everything. Prepare accurate ledgers, including any credits for partial payments you received by either the tenant or a third party, the state, a local municipality. Credit them for everything. If you have to use an Excel spreadsheet, I would do it. Plug it all in. Once you determine what amounts they owe and for what time period. Remember, you have to put the dates in that it became due so you can determine, was it the protected period? Was it the first part of the transition, the second part, the third part? Once you get all that put into a spreadsheet and you figure that out, determine which is your best path. Do you want to go small claims? Have they been a great tenant? You want to keep them there? You want to work something out? You want to do an agreement? Or do you want to go through with an eviction? A lot of landlords at this point, they feel like the tenants have been gaming the system. And let's face it, a lot of them have. And I speak to several people every single day that tell me, Mike, now it's principal. I want them out. Okay. So if that's your decision as to which path is best for you, move ahead with it. Review and assemble all of your notices that you served during COVID. Again, you can use these slides. These slides won't have the exact language required, which is kind of why I'm saying don't try to do this yourself. Just send everything over to us. We'll figure out what you've served, when you served it, and whether it complied with the law or not. But assemble those, look at them, make sure you served your tenants the informational notices, look for any declarations, go through your emails, get your whole package put together, and determine whether any revised notices need to be served at this point. Again, we can help you out with that. It's not too difficult to figure that out once you look at everything you've got. And then submit your application. Once you know your numbers, once you know how much you're going to be seeking in the eviction, submit your application to housingiskey.com and get that email back from them as quickly as possible. I would encourage you to make sure you've white papered them in your spam filter. If you don't hear from them, reach out to them. Make sure you get those emails. Keep all of your communications from the rental assistance programs, no matter who they are, in case you need those in the eviction. And then anticipate all the defenses that the tenant's going to raise and prepare the documents to prove the tenant wrong. And as part of the new documents that the Judicial Council came out with, they came out with new complaints, new verifications, new declarations. They also came out with a new answer that the tenants are to use when they're filing it in an eviction. And that new answer lays out all of the different defenses the tenant can raise for COVID. And so I would anticipate those. So for example, you can anticipate that, oh, your notice is defective because it overstates the amount due. That's why I say do a ledger and prove that it's not. You never served the notice. Ideally, if you served the notice, you took a picture of it on the door. But even if you didn't, worst case, you have your declaration of service for that notice. If you handed it to a person, have a physical description. Every single defense that they can say, oh, I didn't owe the money. Well, show your ledgers why they did owe the money. They didn't comply. They never served me the informational notice. Well, again, hopefully you have a picture of it on their door. If not, it's in your declaration of service. There's a whole slew. They never complied with the CARES Act. It violates the CDC. That one you don't have to worry about. But anticipate everything the tenant's going to say, including the defenses that they could raise pre-COVID. So, of course, any landlord who's been a landlord for longer than 30 days knows the first defense the tenant's going to raise in an eviction suit is habitability. So get your documents together, gather those documents as well to show, for example, your move-in, move-out statements that shows when they took possession of the unit, it was a clean unit. They signed off on it. Any repair receipts that you might have. Get everything together because it's going to be a bumpy ride if you move forward with that eviction. You've got new defenses they can raise on top of the old defenses. Once you get all that together, I would encourage you to meet with your attorney after they've had a chance to look at everything. And again, it doesn't have to be meet in person. You could do a Zoom call, you could do a phone call, whatever it is. Decide your strategy and then move forward with whatever you decide to do. There's a lot of strategies. I don't go into a lot of the strategies on the webinars because, as I've said a lot of times, there's tenants' rights, law firms, and activists that watch these type of seminars and webinars, and they take the things I say, and then they develop strategies against my strategies. So there are strategies we can talk about that may get you by various moratorium requirements. For example, the city of LA says you can't serve a notice for non-payment of rent or any type of termination notice right now. Even for your non-payment of rent cases, I interpret the law and I have a strategy that says you can do that under the proper circumstances. I'm not going to go into what those circumstances are during this webinar because, like I said, people watch this and I don't want them to understand my strategies. But talk to your attorney, figure out what your strategy is, and then move forward. So that's your prepare for success. And then really, here's your conclusion. The statewide eviction moratoriums have not expired. You've got 3 laws you need to be fairly fluid with: AB 3088, SB 91, and now AB 832. AB 832 simply adds that new layer of responsibilities and new forms and new hearings, new declarations, new verifications. But there's good and bad to AB 832. The good of it is, as of October 1st, 2021, a few days ago, the tenants owe 100% of the rent again, and they owe it on the due date. There's no more pushing these 75% off and 25% in 6 or 8 months or 12 months or 18 months. That's all gone. The 3-day notices for rent that's unpaid and accruing on or after October 1st, we're back to 3-day notices, though I did say those really turn out to be a 23-day notice. The expanded just cause evictions that were implemented under AB 3088, SB 91, those are gone. So if your property was exempt from statewide rent control pre-COVID, you're back to being exempt under state law. You're back to being exempt under AB 832. So you could do a 30 or a 60-day unless a local moratorium prohibits it. And then your new tenancies are not protected by these new laws. And then landlords of qualifying tenants, that you receive 100% of your unpaid rental COVID debt now. So there's a lot of good that's going to come out of AB 832 as it progresses. But there's also a lot of bad that AB 832 tends to keep in place. It continues the tenant protections under AB 3088 and SB 91. It has the potential, anyway, for prolonged delays even after you've filed your eviction. There's new documents, new declarations you have to sign under penalty of perjury. It's got no language clarifying the preemption aspect. The preemption aspect goes back to what I was talking about before. There's this debate right now in AB 3088, SB 91, and AB 832. They all have that provision that says whatever the local municipality had on August 19th, they're stuck with. And myself, as well as every other attorney I know, interpret that as a preemption clause that anything after August 19th, your local municipality like a county or a city, you can't modify your eviction moratorium. You can't create a new one. You can't extend it. And many of you know that many of the local moratoriums have been extending their, many of the local jurisdictions, I should say, or municipalities, have been extending their moratoriums, notwithstanding that preemption language. So in my opinion, those extensions and those creations are illegal. But I will caution you, I know other people take a very aggressive approach and say, because they're illegal, we're still filing evictions and we're not following the laws in those moratoriums. I say be cautious and talk to your attorney because, for example, the county of Los Angeles, the city and the county, city of LA, county of LA, they both LA's didn't have an expiration date, so theirs is implemented and it remains in place. County of LA initially had an expiration date. They keep extending it. The county of LA and the city of LA both, for example, say no fault evictions. There are some people out there that says if the property's in the county and it's not governed by the city's moratorium, I'm doing the no fault evictions because I think that provision, the extension of that moratorium, is illegal. I agree with you. It is illegal. I agree with anybody who holds that opinion. But I caution landlords, before you decide to move ahead with an eviction that is otherwise prohibited under that local moratorium, you should probably determine what the penalties are for that. For example, under the Los Angeles County moratorium, the penalty for that is $5,000 a day. Do the math. 30 days is $150,000. So the city of LA, they offer a safe harbor. If you violate their moratorium, they also have a penalty, but they actually give if you want to talk about an exercise in irony, listen to this. The city of Los, you as landlords have to serve the tenants 15-day notices to comply or quit. If you violate the city of Los Angeles's moratorium, the tenant actually has to serve you a notice, a 15-day notice, saying, hey, you're violating the moratorium. You have to, for example, rescind that notice. So you have a cure period or a safe harbor period that you can fix it. Under the county of LA, they have no such cure period and no such safe harbor. So you're fined $5,000 a day if you violate their moratorium. So, like I said, I agree that the moratorium, the extension of those moratoriums is illegal. But I think before you make a decision as to whether you want to go ahead full steam and move forward and file your evictions, violate the moratorium, you need to understand what the risk is and then do a risk assessment. Am I willing to risk $150,000 for every month or $5,000 a day simply to move forward right now? I don't know. Maybe you are. I have had clients that have told me, hey, I don't care. I want to be aggressive. I want you to move forward. And we've done it on their behalf. So that's one thing you need to keep in mind. The state law is very separate from the local moratoriums. Really, the way before I shouldn't say before, in addition to understanding the state laws, probably more importantly, I would encourage you to be fluid and very thoroughly versed in your local moratorium so that you can build a strategy that's going to be effective and not get you in any trouble. And like I said, again, when we're talking about the bad of AB 832, there is language in there that says it goes through March 31st of 2022, but there's nothing in there that says under no circumstances can this be extended. So, given the whole situation right now, the Delta variant, the flare-ups in cases, the ups and downs, I would not at all be surprised if the state came out and extended AB 832 and the protections. But we are getting, like I said, I can see the light at the end of the tunnel. We are back to 3-day notices. I can see them starting to phase it out. I am hearing about municipalities that are starting to ask the staffs to go back and devise a phase-out period for their local moratorium. So we are coming out of the whole thing. It still may be very slow and certainly slower than most landlords would like to see it happen. But you've come through it for 18 months now. Stick with it, be patient. And in light of the fact that a lot of these tenants will qualify and the landlords will receive 100% of the unpaid COVID rent, things could be a lot worse. Let's just all pray that, the COVID gets better and the Delta variant or any other variant, we find a way to get that under control, and there's no reason to keep these laws moving forward. So having said that, this seminar is over. That's the conclusion. I'll remind you one more time. Don't try to do this stuff yourself. Please seek out a very well qualified landlord-tenant attorney, not just any attorney that says, yeah, I do landlord-tenant law. Make sure they've been doing it for a long time. They know the ins and outs of it. put somebody who knows what they're doing and their skill set and their knowledge to work in your corner. Believe me when I tell you the tenants have a lot of people working on their side, so get somebody good on your side. Be patient, get your due diligence together, get your documents together, talk to your attorney, and have them help you navigate through this stuff. And that's it, Jeff.
Wow, thank you so much. That was very comprehensive, and it's great that there's slides there. They'll be able to get those slides from you. I think we'll also be able to send that out to people who registered. So that's awesome. We're going to take questions now. But before we do, if you're on the AOAUSA.com, you can submit your question by clicking on the blue help button that's at the bottom right. So submit your question there. And then, of course, if you've done it in YouTube or Facebook, we selected a few questions from last week that we just did not have enough time to answer. So we will start with those questions. But before we do, many of you may have missed the very beginning part. You can catch that by going to YouTube and then just searching AOA USA. And then all of the videos will come up, and it'll be the first video that's up there. And then you can catch it from the beginning, just in case you happen to miss it. And then also, you think of like the Supreme Court, and there's people that these are the experts in their field, and they interpret the laws differently. And so we have Michael Brennan interpreting the law, and with all of his experience, and then there's others as well. So we had Block last week. Next week we will have one with Richard Beckman for Northern California. So I think all these videos are great for everyone, for the statewide. And then when you have specific questions, Southern California, Northern California, we're trying to just give you what we can because we know there's a lot out there. And I'm so glad that there's people like Brennan around that you can call and they'll answer the phone. You'll talk to a live human and clear things up for you. And so with all this, just you can subscribe. And then also, if you like this kind of content, that's when you want to subscribe. But also, if you hit the like button, it will help other people see it, because Google will take those analytics and then put it out to more people. And that just helps everybody in the whole industry if you do that. So if it's good, if it really is, then go ahead and click that. And then also sign up for the newsletter. All those are things that you can do just to be aware. And if we do go live with something, then you're right there, and then you can put your question in. And anyway, and so then also one other thing is that we are still moving forward with a protest, because there are so many places where, like he said, the eviction moratorium has not ended for many places. Excuse me. So we wanted to just continue to remind you on the website, there's a banner across the very top of the AOAUSA.com. Join the protest, send the picture, send it to the LA City Council if that's where you live, if you're up in Berkeley. And then also even the LA County, we need to send something to them too, because whether you choose to ignore that, their ordinances or not, there's still people that need to hear your feedback. So County Board of Supervisors, Hilda Solis, there is specifically the one that you want to write to for the LA County. But we need to get out there. We need to be active. They need our feedback. And, these people, they are really clueless. Today in the LA Times, there was an article. It said, let courts help tenants through the eviction process. And this is just an opinion piece. This is a great one to go troll and let them know what reality is right here. But really, it's sending out those letters, joining the protest. There's so many different ways that you can influence people, and we ask that you do, because I think a lot of people, they're not really aware. They're not really even thinking about these things, like the contents of that article saying that, tenants shouldn't even have to go through this process. And so basically, let's just remove all justice for both parties. Let's make this totally one-sided. And it's like, they need to know that there's another side to this thing. So anyway, so I wanted to mention all of that. And then We're going to spin the wheel one time, and if you win, whether you're an AOA member or not, we're going to give you a 1-year membership to AOA. So let's spin it real quick, and we'll get a winner. So if you registered for this event through Eventbrite, and that's through our website, then you're in this drawing, and we're going to pick one name. That person, Mary Martin. There you go. Congratulations, you got it. So if you call in and set up a membership, we'll make sure that that's 1 year is free for you. And anyway, congratulations. But let's get to questions. Okay, on YouTube from last week, this is Shoab Ahmad. For properties not under local rent control moratorium, when can we start collecting late fees?
October 1st. I believe it's October 1st.
Okay, so you can collect late fees, and then should it be a daily amount like $5 a day or a flat $75?
There's a case law that has stated that 6% is not an unreasonable amount. So in general, we've generally told people 6% of the monthly rent. Their judges have taken a different opinion about that. They do it on a daily basis. Some of them will do it on a daily basis. But I think if you can go to court and reasonably show the judge, if the tenant misses it, I've got to create a notice. I've got to have either I do it or my wife or my assistant will have to go serve that notice. Show them the reasonable value of your time, and as long as your late fee provision in your lease is what we call a liquidated damages provision, and is not unreasonable, you should have no issues with late fees.
All right, here this one came from the chat. Last week, Victoria, if a tenant has not paid the 25% of their balance due during the protected period, and they are in a city that no longer has a moratorium, should we give the new 3-day notice when they don't pay October's rent?
I'm sorry, can you repeat the question, because I think
right.
She said something that conflates two different periods, but go ahead.
So if a tenant has not paid the 25% of their balance due during the protected period, and they are in a city that no longer has a moratorium, should we give the new 3-day notice when they don't pay rent in October?
Well, so you're going to give the new 3-day notice for October's rent, but you still have to use the old notices. She's saying the protected period, which is kind of what's throwing me off. The protected period has a very specific notice that has never changed. And if that rent came due under that protected period, yes, you would have to serve the notice for the protected period. Plus, if they didn't pay October rent, you'd have to serve the 3-day for the October rent. Plus, if they owed money for the transition period in between those two periods, you would want to serve a notice for that as well. So yes, you would reserve those notices. Alternatively, if you served a notice and they didn't pay it and they haven't returned their declaration, or they haven't returned their declaration, you could go ahead and file right now without serving the notice for October.
Right, and that's all if they've already applied for the housing is key.
Correct. Yes, I would encourage you first to apply for the rental assistance funds.
Right. Okay, Mary Kong on Facebook. Can we sell or assign debt now that state moratorium has expired?
Well, again, I want to keep pointing this out. These moratoriums have not expired yet. And to be candid with you, I don't want to answer the question because, honestly, I don't recall what the code says about selling the debt. I know it phases it back in. I don't recall the date off the top of my head. I was really focused on the evictions, not on so much on the collections end of it. It is phased back in under 8B 832. I just don't recall the dates. If she wants to, I'm sorry, what was her name again? If she wants to either call my office or email to info@mbrennanlaw.com, I'll look that up for her and I'll reply and get her an answer for the specific date.
Yeah, that was Mary Kong.
Okay.
All right. So Kyla, on YouTube, what if the tenant never provided a signed declaration?
So you could file the eviction right now because they did not comply with AB 3088, SB 91. You could file that eviction now, but again, I would encourage you to go apply for those funds first. The legislative intent is clear. They don't want to evict people. They would rather you resolve this through receipt of the rental assistance funds or through small claims. But there's nothing more she needs to do. They didn't comply. She could file the eviction. Nothing more she needs to do other than file the application for the rental assistance funds.
Right. Okay, great. And then Ron on YouTube, what happens if the tenant doesn't do their part for rent relief?
So that's a great question, because that is specifically dealt with. If the tenant doesn't do their part, there's two ways they could not do their part, right? They could simply refuse to submit an application. That's your 20-day period. If they don't submit an application within the 20 days, you can go file your eviction. The other way they could not do their part is they submit an application, but then don't submit the supporting documents or information that is required. And in that point, eventually you are going to be able to file your eviction after your 20-day period expires. But remember, you've got to get that final decision first. An application that is pending is not a final decision. So you're going to have to get the final decision from the rental assistance program that, hey, okay, they've been rejected because they didn't complete the application. So this is where I see the tenants will have the ability to kind of game the system a little more. They'll submit an application, but then they won't submit the supporting document. And that application will sit there. It doesn't specify how long the rental assistance program has before they can give you a final decision. So they can sit there waiting and waiting and waiting, theoretically, for that tenant to submit that documentation or provide the information. And like I said, I think that's where the savvy tenants will play the game.
Will you try to get the judge to order them to submit it in a certain time period, or
well,
how will you work with
you've
that?
got to meet the requirements before you can even get in front of the judge.
Oh, that's right, yeah.
You can't even, the court will not issue a summons without all those declarations, verifications, and the landlord signing off that they've done certain things and there being a final decision or the passage of the 20 days. So in the long run, if the tenant doesn't do anything after the 20 days, then you're going to be able to file your eviction. But like I said, I think the tenant can play games with it.
All right, here's Sharal. What can we do if a tenant owes rent but moved out months ago?
So we talked about that a little bit. As of November 1st, you're allowed to file the small claims actions. And my interpretation of these laws is it doesn't protect them. Nowhere does it say tenants who have vacated are protected by these laws as well. And they have to follow the moratorium period. So what I interpret by the absence of that protection is that as of November 1st, for a tenant who has vacated, I would go ahead and file my small claims action for the entire amount. By the way, just a quick reminder, under SB 91, there is no cap in small claims for COVID debt. They could owe you $150,000 and you're still allowed to file that in a small claims action. So if they've vacated, just go after them full force.
Right, and small claims is November 1st that when they can start filing for that.
That's
November
correct.
2nd, I believe, we'll have Franco Simone. He's an eviction attorney that's in San Diego. He'll be speaking and about how to prepare for that. And obviously, Michael Brennan can also help you prepare for that.
Yeah, you know, admittedly, it's going to be a service that we offer our clients.
Yeah.
We're going to be putting together all the documents. We'll draft the documents so that your pleadings are accurate. We'll put your documents in order. We're going to be creating trial binders for you. We're going to be calling you 1 to 2 nights before your trial to walk you through what you need to prove for your case and how to say it to the judge. So it is a service that we will be offering landlords.
That's great. And that's important because you have to have all your
I mean, you're going to have to prove your case.
I's dotted.
You'll have to prove your case just like an attorney would, even if it's in small claims court. So we'll help you do it. We're happy to help you do it.
Great. And I failed to mention this, but guys, if you can be real specific with where you're located and the number of units that you have, what year it's built, if it makes a difference with all this stuff, it'll help answer your question accurately. So here's Cheryl. She did a great job on YouTube. City of LA, RSO, landlord. Here we go. Should we start serving 3 or 15-day notices to the tenant? My tenant has not paid since April of 2020.
Great question, because she did bring up she's in the city of LA.
Yeah.
The city of LA specifically prohibits her from serving notices. So like I said multiple times throughout the webinar, AB 832 allows you to go ahead and start serving those notices, but you have to look to your local moratorium, and her local moratorium prohibits it. But again, I would like her to call me, because my interpretation of the city of Los Angeles's moratorium sets up a situation where under the right circumstances, she's permitted to serve those notices, and I would like to talk to her about that and see if those circumstances exist for her.
Oh, that just begs the question, what are those circumstances?
Those are the circumstances I won't go into on a webinar, because I believe that I know for a fact the tenants advocates watch these webinars, and then that's my strategy. And then they're going to build a strategy around that, and they'll go to the city and say, hey, look what these landlords are doing. And the city's going to look at the moratorium and say, hey, you know what? He interpreted it nicely, and now we're going to change it so that they can't do that anymore. So I won't discuss strategies ever on webinars or in seminars. If they want to talk to me, anybody who wants to talk to me about what circumstances in the city of LA would allow you to serve a notice to terminate tenancy, I'm happy to talk to you about it.
Great, there we go. Annie, apartment is in orange. How to count 25% rent paid? Tenant paid rent in full up to December 2020. Tenant stopped paying since January 1st, 2021. Is it counting from January 9th, 2021, or the whole transition? From January through September 2021, or the whole transition period, September 2020 through September 2021?
Good question. The law is not entirely clear. As I said at the beginning, these are very convoluted laws. When you start to implement them, they're open to different interpretations. What each one of those laws said, AB 3088, SB 91, AB 832, they all said that when you're dealing with the transition period, they have to pay 25% of the amount demanded in the notice. So there's different ways to interpret that, and there's different ways to apply that. One way will net the landlord more money. And again, I'm not going to get into how to do that on this webinar, because the tenant's rights will come and argue against it. But anybody who wants to talk to me about how to fill out those notices in a way that will net you more money, I'm happy to talk to you about it. Call me, be patient. Admittedly, I'm as you can imagine, I've got a lot of people calling me every single day and emailing me and texting me. And so anybody who's listening to this webinar, if you're going to call, please be patient. I will get back to you, but it might take a little bit. But I'm happy to walk through how to do that 25%, but just be clear about the fact that these laws have not been interpreted in court yet. And so that is one of the areas that will need to be clarified by judges and by appellate courts down the road.
All right, here on YouTube, Reginald has a question, and if they owe a year's rent and they don't qualify for the rental assistance, plus they moved out, what are their options when they don't have a forwarding address, and when the housing provider doesn't have any job information? What's the best way to track them down?
So they've moved out. Like I said, it's my opinion that you could move forward with a small claims action and get a judgment against them right away. As far as finding them, that's going to be your challenge. How do you find them? There are resources on the internet that will help you do that. But more importantly, there are attorneys. Our office does collections as well. We use certain databases that are able to locate people. It will take a while. It takes a while for their name to show up in these databases. But if they're attempting to use any form of credit or get utilities or something along those lines, they are going to appear. And so, you can call it whatever you want. Sometimes I jokingly refer to it as marinating. When they've moved out, you let it marinate for a while before you do anything. And then, 6, 12, 18 months later, you start looking for them. You are within your statute of limitations to file that case. So I wouldn't worry about it too much. If you want to proceed this, if it's an oral agreement, they've got 2 years from the violation. If it's a written agreement, you've got 4 years under the statute of limitations. Don't worry about it right now. Contact an attorney or somebody that can help you with those databases. Like I said, there's resources on the internet. You could do it yourself, locate them, and then you can get them served. You can go after this money. There's ways to do it.
All right. And we got tons and tons of questions, so let's just go like speed round because there's so many. Paula, what's next for Pasadena? Do I need to ask a tenant? Oh, I need to ask a tenant to vacate to house my granddaughter. When will the moratorium end for Pasadena?
Well, I don't know when it will end, but more importantly, you've got to also look at the county of LA. Los Angeles County's moratorium specifically says that it applies in both unincorporated Los Angeles and in areas where the city itself is incorporated, and it takes the more stringent of the two moratoriums. So in her case, and in the case of many other people, anywhere in LA County, you've got to look at both moratoriums, the city's moratorium and the county's moratorium, and pick the more stringent and go by that. And as far as counties is concerned, the county's moratorium won't expire until the end of the state of emergency. And we don't know when that's going to be yet. I will say that there are multiple lawsuits out there suing the county, suing cities for these never-ending states of emergency, for the constitutionality of it all. What I would suggest to her is to call my office, give them your email address, sign up for our newsletter, and when it ends, as soon as I get information, important information like that, I typically will do a newsletter and blast that out.
Great. And here on YouTube, Jill, how long does it take to actually evict someone from start to the time of the lockout?
You know, believe it or not, that will depend a large part in where you are. Where's your property? What court are you in? Different counties have different speeds. Orange County is much faster than LA County. In LA County, it will also depend on the case, what the case is about. If you've got a non-COVID rental debt eviction, so for example, a nuisance eviction, we've had cases move pretty quickly because of the severity of the nuisance. If you've got a rental debt eviction, remember, you've got additional requirements you have to meet. They've got 2 additional hearings they can utilize now. So it really depends on the city, the county that you're in, the court you're in. Many courts are not afraid to tell you that their political leanings just by their rulings. So it depends where you are. It can be on the very low end. Let's assume the tenant did not file an answer and it's going by default. On the very low end, you're going to look at 6 weeks to 8 weeks, very low end. On the high end, for just a standard didn't file an answer, you could be looking at as much as 60 to 90 days. If it's a contested case, you could be looking at the low end of 60 days to that's the very low end, to the high end of 120 to 180 days, just depending on how the tenant plays the system. If they file a bunch of motions, if they hit you with discovery, you hit them, if they demand a jury trial. I can tell you, for example, Los Angeles County, the courts are starting to open up. We went from no jury trials to 8 jury trials on calendar next week alone. So, you know, and that causes a backup itself. So they're not fast, but they're certainly not as slow as a regular civil case. They're starting to move forward, but you can still expect delays.
Great. Thank you, Mike, for giving lots of different scenarios there, because, you know, that's a broad question, and there really are lots of different ways that it can play out. K Prism. Since we can't evict or terminate a lease, I asked my tenant to leave because I had to sell. Thankfully, she agreed. What kind of agreement can I send her for both of us to sign?
So I love this question because, again, it offers an opportunity to look at the nuances and to give her some good guidance on how to avoid problems. You have to look at 2 things in this case. You have to look at your local moratorium and see if they require anything specific, but you also have to look at your city. Are you governed by a rent control ordinance? Again, I'll use the city of LA as an example. In the city of Los Angeles, we call those a voluntary vacate agreement. In order for a voluntary vacate agreement to be enforceable, you have to submit certain documents to the tenant. They have to sign them. They have to have certain language in them and apprise them of certain rights they have. You have to have certain language in your voluntary vacate agreement in 12-point font right above where the tenant signs. And then that voluntary vacate agreement has to be filed with the city. So it depends on where she's at, but they are completely legal. But again, there's another component she should consider as well, and everybody listening should consider. Again, going back to the city of LA, they just recently passed an anti-tenant harassment law that says you cannot offer the tenant money in an attempt to coerce them. So you may think that you're just trying to do a voluntary vacate agreement. If that tenant interprets that as you trying to coerce them to leave, then you could be violating an anti-tenant harassment law. So much of this depends on where your property is located. It's hard to answer. I'm kind of glad that it's hard to answer because it gives me an opportunity to explain that to people.
Great. All right. In the chat, Michelle, West Hollywood, tenant has not paid rent. Can I serve the new 3-day notice immediately, or do I have to wait 7 days because LA County Extension says that we can't evict for non-payment if the tenant provides a notice within the 7 days of the rent due date that they are having COVID-related financial distress?
So hang on a second. Let me work through that. First of all, let's address the West LA. Was it West LA?
West
or
Hollywood.
West Hollywood? Yeah.
West Hollywood.
Let's address West Hollywood. The last time I checked, and that's been a couple days now. Last time I checked, West Hollywood was trying to determine whether they were going to extend their moratorium. If they didn't extend it, then she's right. They fall under the Los Angeles County moratorium. But the Los Angeles County moratorium allows them. There is no. Maybe I wasn't clear about this. I apologize. Under AB 832, there is no more declaration. The tenants don't get to turn in a declaration of COVID hardship anymore. You serve them the notice, and if it's for rent that accrued October 1st or later, you serve them the notice, and it's the 3-day notice. There's no declaration. Now, if she's talking about notices for the protected or transition period, then yes, they still have the 15-day period to turn in that declaration. It's not, the County of LA acknowledges that when it comes to non-payment of rent, they are bound by state law. And state law for the protected and transitional period was AB 3088 and SB 91. So it's not a 7-day window, it's that 15-day window under state law in which the tenant gets to return that declaration.
Jeez.
It gets very complicated.
You know, it used to be a lot simpler.
Life was simpler back in the day.
Yeah, and COVID has just put it over the top. All right, here's Jeffrey on YouTube. What's next for Palm Desert and Cathedral City?
Candidly, off the top of my head, I don't know. I would have to, the vast majority of my business is centered around LA County, Orange County, Ventura County. I don't know off the top of my head. I'm happy to look up those moratoriums. If I recall correctly, and don't quote me on this, if I recall correctly, their moratoriums actually expired, which put them under state law. So if they were under state law, it'd be AB 3088, SB 91, and now AB 832.
Okay, thanks, Jeffrey, for that one. Here we go. Joe, City of San Gabriel, can we start assessing late fees for residential and commercial tenants?
So again, you've got to look at your local moratorium, and that's going to be LA County. San Gabriel doesn't have an eviction moratorium in place, and I believe your local moratorium, your LA County moratorium, says no late fees. And remember, going back to what I said a few minutes ago, LA County specifically stated that not only does their moratorium apply in unincorporated areas of LA County, but it also applies even if a city is incorporated. You have to take the most stringent, you can have a city that's incorporated that had a moratorium that expired, LA County would control. You can have a city that's incorporated that has a moratorium that has not yet expired, and if LA County's is more stringent, LA counties would still control. So San Gabriel, I don't recall if they had one, but even if they did, I know it is expired. It expired last year. So they would be under LA County. And again, like I said, I believe LA County says no late fees right now.
All right, here's Kurt on YouTube. Does the new 3-day notice require applicants even though non-payment is not COVID related?
I am not sure I understand that question. Would you mind repeating it?
Does new 3-day notice require I can't. Yeah, this is kind of hard for me to read too. It's just not written well enough for me to get it.
If you want to read it one more time, it does the new
3-day notice
require applicants
requirements apply even though non-payment is not COVID related?
I love that. Another great question. So how do you know that the non-payment is not COVID related? We have a case right now that the tenant claimed it was COVID related, simultaneously posting all over their Facebook page from their vacations in France, from their vacations in Miami. talking about how well their business is doing, etc. So in that case, we still filed the eviction because we used their own Facebook pages and posts to prove that their non-payment of rent is a scam and it's not COVID related. The question is, how do you prove it? If it's not COVID related, then all of these laws and protections specifically state that they are designed to protect COVIDs in non-payment of rent cases where the tenant has been negatively impacted by COVID. So if they haven't been negatively impacted by COVID, then theoretically they're not protected by these moratoriums and you could move forward. But you've got to prove that, right? And so how do you prove it? Some of these moratoriums, again, going back to the LA area, many of them in the LA area, specifically stated you can't even ask the tenant. And the tenant can self-declare simply by telling you or sending you an email saying, hey, this is COVID related. So you have to look at, can you prove that it is unrelated to COVID? And if you can, what does your local moratorium say? And like I said, that's not the only case we have where we've done that. We have moved forward where we think we've got enough evidence to prove the tenant is scamming.
Great. Okay, here's Abby on YouTube. What can we do with commercial tenants in the city of LA?
Well, you are under the city of LA's moratorium. So they are still protected. They will be protected until the expiration of the state of emergency. So you cannot do anything in the city of LA. And then just, by the way, the same thing holds true for the county of LA. All of these laws that we've been discussing today are strictly applied to residential tenancies. So anything to do commercially, you have to look at whether there's a local moratorium. If there's no local moratorium and it's commercial, you can do whatever you want. You're back to regular 3-day notices or whatever the cure period in your commercial lease says. But if there is a local moratorium, then you have to say, does it apply to commercial? And if so, what are the provisions that apply? Like I said, in the city of LA, she can't do anything.
So commercial tenancy they're protected in
For
LA.
non-payment of rent, yes.
Yeah.
Yeah.
Great. Thank you. Okay, Nick Ryan, 96, duplex in Los Angeles County, unincorporated Whittier. Tenant is on a month-to-month lease and moved in 1 month ago. When can I perform a no-fault eviction and get him out?
So you're unincorporated Whittier, which puts him under the LA County moratorium, so the answer to that is we have no idea. Their expiration date set for the no-fault evictions specifically states is, at the expiration of the state of emergency. Well, when's that going to be? We don't know.
Right, and here's a question that kind of relates. Janice on YouTube, what do you expect the no-fault eviction law for single-family homes to be lifted soon?
Well, it was lifted under state law. So you have to go under AB 832. Those extended just cause eviction protections were lifted. Those no longer exist. So again, you always have to go back to that local moratorium. What does your moratorium say about no fault? We just talked about LA County, unincorporated. It specifically prohibits no fault evictions. You can't take your property off the market. You can't use Ellis Act. You can't do an owner occupied. You're stuck with, in LA County's case, non-payment of rent or some other breach of the contract except unauthorized animals or occupants that are directly related to COVID.
All right.
And some nuisances.
Great. Okay, on YouTube, Joseph, can we serve a 60-day move-out notice now with a property with no rent control?
Essentially, this is the same question as the last question. Depends on where your property is. If your property is in a city that has no controlling local moratorium, AB 832 lifted the just cause requirements. And so, yes, you could terminate, assuming your property is not subject to AB 1482. Yeah, you could serve that notice right now. But if you're subject to AB 1482 or any sort of local moratorium that prohibits no-fault evictions, then no, you can't do that.
All right. Yeah, make sure you guys mention the city with your questions. Here's Raji. Are all the topics of this discussion applicable to properties in the Orange County area?
All the topics, yes, they're applicable to Orange County because these are state laws we're talking about. But for example, Santa Ana has an eviction moratorium. You always have to go back to your local moratorium, whether that's a city moratorium, a county moratorium. But yes, all of the laws we just talked about they're applicable throughout every city and county in the state.
Right. And then specifically, I'm kind of wondering with Orange County, you just mentioned Santa Ana, and that's kind of a new one where they have rent control now, I guess, too, right? They passed a rent control ordinance,
Well, are,
I
you're talking
believe.
about rent control versus eviction
Right,
moratorium.
right.
Um, if there's a rent control, people often use rent control synonymously with no fault evictions because oftentimes a rent control ordinance has a no fault component. So in his case, if that has been passed and there's a no fault or just cause component to it, then in his specific city, he has to look and see what that no fault or just cause provision says. But again, the answer to his question is yes, everything we talked about applies to Orange County.
Right. Okay, on YouTube, Sue Chen. In my UD trials, tenant moved out. The UD became a regular civil case for back rent payment. As it is a jury civil case, the continuing will cost in legal fees. Will it be better to do a small claim?
Um, it's kind of 6 to 1, half dozen to the other. It won't really make a difference for her. She's already in the court system, so there's going to be additional attorney's fees. Hopefully for her, the tenant did not amend their answer and bring any sort of a cross complaint against her, because in an unlawful detainer, you're not the tenant, the defendant is not allowed to bring any sort of a cross complaint against the landlord, and that's one of the benefits of an eviction. But once it gets converted to a civil case after the tenant vacates, then they can amend, assuming the tenant has not amended and brought any sort of a cross complaint. Like I said, she's already in the court system. She's got a trial date. My experience is that more often than not, the tenants fail to show up at that trial date. And so I would, if it were me, I would probably just simply move forward with the case she's got right now.
All right, thanks. Best of luck to you, Sue Chen, for sure. Here we go. Amelia. Can we serve a 60-day notice on a single-family residence in Compton?
Compton is the city of LA, so the answer to that is clearly no.
Okay. All right, Marie, do you recommend that I add to the rental contract a new tenant that moved in illegally to the apartment in an RSO area? And if so, can I increase the rent for him?
There is no increase in rents in RSO units right now. I think it's up to you. I would certainly recommend, if you're considering doing that, get an application from that individual, do your background check, your due diligence, figure out, is this the right tenant for me? And if it is the right tenant for you, the challenge she's really going to face is under the RSO, you have a certain very narrow window in which you can increase the rent for an additional occupant. And in that window under the local eviction moratoriums passes, and there's nothing you can do about it. It's 60 days to accept and increase that rent. If you accept rent and you haven't increased the rent for that additional occupant under RSO, you've accepted that tenant as a tenant, and you're now no longer to increase that rent except your yearly allowable rent. Once COVID hit and all these eviction moratoriums went into place, you weren't allowed to evict for unauthorized occupants, especially in LA, and you weren't allowed to increase rents. So you're kind of stuck. What I had recommended to clients who faced that situation at the beginning, and I still do, is if you're a landlord that has to accept the rent, assuming that tenant is paying rent, if they're not paying rent, you're kind of in a good position because you can reserve your rights about this unauthorized occupant for the end of the local moratorium. But let's assume you're one of the landlords who doesn't have a lot of cash to play with, and your tenant is paying rent every month, and they moved somebody in, and you can't evict them because the eviction moratorium prohibits it. What I recommended to the tenants or to the landlords in that situation is just specifically send a letter to the tenant saying, hey, I am not accepting this. Right now, the eviction moratorium prohibits me legally from evicting you, but I am not accepting this additional occupant as a tenant. And I am not, I am reserving all of my legal rights to evict you as soon as this moratorium expires. So if she hasn't done that yet, I would certainly do it right away. There's no guarantees that will protect her. After these moratoriums expire, she may just be stuck with this individual, this unauthorized occupant. And so, like I said, immediately I would get that person an application and have them fill out the application and determine, do they even qualify as an occupant to live here? And even under the RSO, she still has the right to do that. The tenants do not have the right to just randomly put somebody in their unit and say, hey, too bad, I've taken on an additional roommate or something. Even under RSO, she has the right to qualify that tenant or that occupant, and she should do it.
All right, here we go. Again, Ron, can a landlord evict a tenant after a 60-day notice stating the M2M lease is terminated because the landlord is taking the property off the market or to sell the property?
So that's two different situations. One is called the Ellis Act, where you're removing the rental property from the market. The other is just, I'm selling the property. Both of those are called no-fault evictions. And it will boil back down to, where is the property located? If you are in the state of California, if AB 1482, statewide just cause eviction, does not apply to you, and the city in which that is located or the county in which it is located have no local moratoriums, the answer would be yes, he could do that right now. But if there's a local moratorium, or if the property is subject to AB 1482, statewide just cause, then the answer would be no.
All right, there you go. Okay, Rosie.
I'm sorry, let me back up. I just misspoke a little bit. You could still be subject to statewide just cause, but you would have to serve the proper notice to terminate that tenancy for the Ellis Act or for to sell the property. So you could do it, but if you're still if there's any sort of a local moratorium, then you would be that prohibits just cause evictions, then you would not be able to do it. I hope that was clear. I feel like it wasn't that clear.
Just give him a call.
Yeah, just call.
Okay, Rosie 133, in the city of San Diego, can you give a 60-day notice to a tenant in a duplex so the owner or child can move in? Oh, this is a lot like that last one.
Yeah, you're talking about owner occupied, essentially, no fault evictions, and the city of San Diego has multiple jurisdictions within it that have different rent control ordinances, I'll call them. And so it's going to depend on literally the exact address of that property. So essentially, if there is in place an ordinance that permits, that has just cause eviction, that permits owner occupancy, most of them do, the state law, the COVID laws under the state no longer prohibit that. So if she's got an ordinance that allows that and there's no local moratorium prohibiting that, then yes, she could go ahead and do that. If she's covered by a local moratorium that specifically says, hey, there's no just cause evictions, there's no fault evictions, I apologize, then no, she would be prohibited from doing that. Even if you think that moratorium is illegal. For example, we talked about LA County. LA County's extension, in my personal opinion, is illegal. They don't have the right to extend it. So I would argue that their just cause provisions no longer apply. But you have to look at that moratorium and see, well, if I violate the moratorium according to the municipality, what are the ramifications? Am I going to get tagged with a $5,000 a day fine? Is that worth it to me? So understand your local moratorium, what it allows you to do, what it doesn't allow you to do, what the consequences are if you decide to move in violation of the moratorium, and do a risk assessment and make a determination, develop a strategy based on that.
Right, and for those specific area down there, we do have an office in San Diego, and you can just call Victoria there, and she'll be able to help you. And we do have offices in Orange County, LA, Long Beach, Los Angeles, San Fernando Valley, up in Alameda, and so those are all places you can either walk into or you can call, and they'll be able to help you. So, all right, let's see. I own a 9-unit building in Long Beach, LA County. I want to move out a tenant from the building as a no-fault and relocation assistance for the owner to move in. Is this allowed because of the eviction moratorium extension?
I'm going to short circuit the answer and just say no, because you've got that property is located in the county of Los Angeles, which currently prohibits no fault evictions. So again,
Right.
Is that moratorium legal? I don't think so. Is he willing to risk $5,000 a day to serve that notice and go ahead and terminate that tenancy? That's up to him. I will say this, whether you're, depending on your risk tolerance, that's a risky move. You're talking about $150,000 a month. So it depends on his risk tolerance. I've had clients that told me, Mike, move forward. We don't care. We want our property back. And candidly, we've gotten it. We've gone to court. Nobody has raised an issue about it. We've done owner occupieds in the county of Los Angeles, and we've gotten the judgment and won. But I tell all of my clients, you know, LA County has that moratorium. They have a fine in there. You're taking that risk, not me. I'm notifying you. So it's up to you.
Right. Great. Okay. Right. Yeah. So just again, another question about how do I get the money? And we already asked that question one time. What if tenants never filled any forms or just didn't pay? We asked that question just a few minutes ago too.
Start the eviction.
Yeah.
If the notices were served and they never completed any forms, file your application right away and start your eviction.
Yeah.
Don't even wait. Don't even wait. Worry about October. If you haven't served notices yet, serve all of your notices at one time. But contact a law firm that will do that right for you. So you have the proper notices, the tenants' rights notices, the declarations. Serve it all correctly and include October's.
And Mike, can you tell us again specifically which areas you serve?
We serve, to make it easy, all of Southern California, anywhere from Kern County down to San Diego, LA, Ventura, Santa Barbara County, I'll go to, Riverside, San Bernardino, and certainly Los Angeles. The bulk of our cases are in the county of LA.
Great. Okay, so that's good for people to know. And then if you're in Northern California, if you look on the website, at AOAUSA.com, you go to contractors and vendors, just type in your area, type in evictions, and then a list of eviction attorneys will come up for you. And so that goes for just anything. You can look up contractors and vendors and find just about anything for your specific area. All right, let's see.
Jeff, I will add that we've done cases up in Northern California, but as I keep suggesting to your members, because of the need to know fluidly all the local moratoriums, I stand by with what you said. Wherever your property is located, your members should be looking for an attorney who understands that local area's moratorium inside and out. There's just too many ways that it can go sideways for your members. So even though I have handled cases up in Northern California, right now I'm telling people who call me to look for an attorney up in Northern California in the specific municipality in which your property is located.
Right. And next week we have Beckman. He'll come in and he's from Northern California. He writes the legal Q&A for the magazine. And so yeah, he'll be there. Okay. Cecilia, single family residence in Downey.
Let's just say LA County.
Yeah.
I've answered that so many times. It's LA County.
You can just say no.
Yeah,
yes. No.
I'm not going to say no because there are evictions you can do in LA County, but it's LA County. So you're going to go to other than non-payment of rent, which is in LA County, non-payment of rent is controlled by AB 832. Outside of non-payment of rent, look to the LA County moratorium to determine the answer to your question.
Okay. Okay. This is on YouTube. Does payment by a rent relief program count as tenant payment of 25% owed?
It can, absolutely.
Okay.
Yeah.
That's a good question.
That is a good question. Yes, it can.
All
so
right.
So realistically, how would it play itself out, right? Your tenant fails to pay the 25%. You go ahead and do everything you're supposed to, file your paperwork. You're going to ask for that 25% in your eviction. And so, as I said before, the requirements by the court now are that you're seeking, in the eviction, you're seeking the same funds you're seeking out of the rental assistance program, right? So, and they are now saying they're going to pay 100%. So the short answer to that is yes, the rental assistance program, and their payments will count towards that 25%. And so will all your paperwork associated with that eviction.
Great. Here's John. In the city of Los Angeles, when a commercial lease expires, but the tenant wants to remain in possession, is there any limit on how much the rent can be raised?
That is a good question. I think where you would run into some problems would be they're an existing tenant, right? So the rent freeze cap would apply to them. You could argue, and we have, that it's a new lease because of the fact they're signing a new lease. But as you saw in AB 832, they specifically carved that out as a new tenancy. So while AB 832 does not apply to commercial, I'm saying that it wouldn't happen right away. You could enter into this contract with an increased rent amount right now. Where it would come up to bite you later would be, let's say that in 6 months the tenant fails to pay rent and you go to evict that tenant. Either the tenant or their attorney is going to argue that, hey, that was an illegal rent increase because it violated the local eviction moratorium that prevented rent increases. Your argument's going to be, well, no, it didn't, because it's a new tenancy or it's a new lease. And while it doesn't yet exist, it does in residential. AB 832 specifically said that would not be a new tenancy. That language isn't in any of the commercial moratoriums yet. I could see a court looking to that and saying, hey, well, that's technically not a new tenancy. It might be a new lease, but it's not a new tenancy. Maybe you should be, governed by what was in place for the commercial tenancies at the time you entered into that. But I can't say, like I said, none of these laws have been heard in the courts yet. None of them. We're just getting to the stage where this stuff is going to be hammered out. So right now, there's no case law I can look to and say, yes, this is definitively how the court is going to rule on this.
All right, Miguel. Section 8 tenant in LA, in 2020, they fell behind in their rent because Section 8 continually paid something, but the behind rent is over $5,000. Would it be best to remodel with permits?
So what the question is really alluding to is, it's in LA, but he's alluding to statewide rent control because what he said was, can I remodel? What he didn't say is, can I terminate the tenancy because I want to do a remodel with permits, which under state AB 1482 state just cause laws, he would be permitted to do that. It's Section 8, so he'd have to serve a 90-day notice to do it. But he's in LA County, and so he cannot terminate that tenancy because that would be a no-fault termination, and LA County specifically prohibits that right now. And again, to repeat myself for the 20th time, LA County, in my opinion, LA County's moratorium extensions are illegal, but there's a $5,000 a day fine. So whether he's willing to take that risk on and do it is up to him. As I just said a minute ago, we have done it for clients who have insisted I do it, and we've gotten those judgments. But I want to be clear that there is risk. If he wants to talk about terminating that tenancy and moving forward, call me. I'm happy to talk to you about that.
All right, Russ, thank you for your question here in the city of San Diego. Multi-unit property, tenant couple gave notice to vacate. She left and he stayed, both names on the lease. He was given notice to vacate. What do we need to do for a UD initiation? So
he's got multiple layers to that. Multi-unit, San Diego, so like I said, San Diego's got multiple jurisdictions down there. 2 people in there. They gave their notice. They terminated their tenancy. Mm-hmm. She leaves, and he stays, I believe is what it said, correct? Right. And they turned around and terminated his tenancy. So the first thing I would say is you need to talk to an attorney down in San Diego and make sure that your notice of termination complies, is not prohibited by any of these moratoriums. The reason I say that is because they terminated their tenancy together. She complied by moving out, so she's done. He did not move out, and then they served a notice of termination. So their notice of termination knocked his notice of termination out. That's the control. Their notice of termination now is the controlling notice. And what I don't know is whether their notice of termination, when it was served, because prior to October 1st, you couldn't, that's called a no-fault termination. Their lease is expired, I think he said, if I remembered correctly. They couldn't terminate his tenancy. So depending on when that notice was served, it might have been prohibited under state law. Now that state law has changed, it may still be prohibited under local moratorium. That's what he'll need to figure out.
All right, Rusty. Good luck. There, again, contractors and vendors, look up the eviction attorneys that are down locally. You also can give a call to the office. Call Victoria there. Boardwalk Real Estate in Santa Monica. If a single-family home is owner-occupied and the guest house is on a month-to-month tenancy, can a 30-day or 60-day notice be given for non-payment of rent, even if some months were paid by rent relief?
I'm so sorry, Jeff. Would you mind repeating that, please?
Sure.
I'm playing with my microphone over here. And
Okay. In okay, this is Boardwalk Real Estate. In Santa Monica, if a single-family home is owner-occupied and the guest house is on a month-to-month tenancy, can a 30-day or 60-day notice be given for non-payment of rent, even if some months were paid by rent relief, March through June 2021?
I'm going to go with I do not believe so, because I believe Santa Monica was one of the jurisdictions that had one of the most stringent moratoriums out there, has not expired yet. And I believe they had one of the open dates that said, hey, we're going to expire, whatever it was, 6 or 12 months after the expiration of the local emergency. The local emergency has not expired yet. You are dealing with a unit that it would fall under the Santa Monica Rent Control Ordinance, but more importantly, you're dealing with a unit that falls under the Santa Monica Eviction Moratorium. So I believe that the moratorium is going to control over whether you can serve those notices or not, and I don't think you can.
Okay, here's a question from Grace. In order to commence an eviction for the 25% owed during the transition period, the 15-day notices served should have only had the amount of the 25%, or was it okay to write the total amount of the rent due? Let me ask that one more time.
Yeah, thanks.
Grace. Okay, here we go. In order to commence an eviction for the 25% owed during the transition period, the 15-day notices served shouldn't only have the amount of the 25%, or was it okay to write the total amount of rent due?
Oh, that's a good question, because I think she has a misunderstanding. The 15-day notice was for the total amount due, and what they had to pay was 25% of the amount demanded in the notice. So if she served a notice that only had the 25% that they were supposed to pay, her notice, she's shortchanging herself. I'm not going to say the notice is defective. She could move forward on that notice. It's understated, but she should do herself a favor and reserve those notices with the higher amount, the full amount that's due, and require the tenant to pay that 25%. Now, I will say, keep in mind that 25%, that date by which they had to pay that, which was September 30th, has passed. But she can still serve the notices, and if they don't file the declaration or don't pay her right away, she can file the eviction. And what we've seen the courts doing over this past week is they are ordering the tenant to pay the 25% within 5 days. And if the tenant doesn't pay the 25% of the amount demanded, they're allowing the case to go forward. So if I were in her shoes, I would reserve those notices for whatever amount is currently owed, and require that tenant to pay 25% of that.
Michael, we've been on this live stream for like almost an hour and a half now. Man, thank you so much for for just coming out here and for presenting. That was a very good presentation. I'm glad we have those slides. I'm glad that we can review that, and just very thankful. Thank you for answering so many questions. And guys, I know there's tons and tons of questions that are there, and just like last week, we carried some over. We'll look and we'll pick like maybe the top 5 again, and we'll ask those next week. Again, it's going to be statewide rent control, but with the twist of its Bay Area. So if you guys are in Southern California, don't ask Southern California questions next week, but you can ask statewide questions. So if you know where you're at, you know what you fall under, then you can still benefit from next week. And again, subscribe to the YouTube channel, and if you toggle the notification bell, you'll know when things are happening. Sign up for the newsletter and become an AOA member for sure. We got that year guarantee. And yeah, and don't forget the protest, because it's at the county level, it's at the city level, where they need your feedback. So go to the AOAUSA.com website, hit that protest, or hit that banner that has the protest on there, and you'll see that there's a picture, there's a form letter. Print those things out, put them in the mail to your city council members, and if you're LA County, definitely Hilda Solis, you can go ahead and write that to her, as well as the other people there. And but yeah, anyway, so thank you so much for joining, and we hope to see you next week.